Hi, Assalamualaikum to Madam Shahila and to all our viewers and friends. My name is Amir Ashraf Begum Afasha, and today we would like to present and share information regarding our topic, which is the public company. In Malaysia, there are several types of business organization, which is sole proprietorship, partnership, limited liability partnership, and also a company. Company is also known as a public companies. Okay. Therefore, what is the difference between the company and the other types of business organizations? So without further ado, let's go to the point number one. Public companies is a large business models for entrepreneurs. Public companies need to be registered legally as per required by the law of Companies Act 2016. According to the Section 2 of Companies Act 2016, company is defined as a company incorporated under the Companies Act 2016 or any corresponding previous written law. In Malaysia, public firms are the most predominant type of corporate structure. The firm conduct business as a thought it were an artificial person that existed independently of its owner, and it is the owner of all assets and liabilities. The business has the ability to enter a contract, undertake a legal action, and be sued. The financial information regarding companies also need to be published to public. The example of public companies is Migrant Berhad, Maxis Berhad, RHB, Petronas, Telecom, and others. Shareholders are free to sell all or a portion of their shares at any moment to a new investor, because ownership can be changed without the firm being dissolved. The company has an infinite lifespan. Public corporation or public listed company have the designation of Berhad or holding at the end of their names, and the ownership of the company requires a minimum of 2 shareholders, with an infinite maximum. The board of directors of the corporation oversees management, and as a result of restricted liability, the shareholder exposure is only as much as the investment in the business. What is the characteristic of public companies? Firstly, public company is not being controlled by one owner. Second, shares is offered to public, unlimited numbers. It is governed by Bursa Malaysia Securities Berhad. Public companies are managed by a Chief Executive Officer (CEO) who leads a team of executives, Vice President, and managers. Public companies require at least 2 directors. Public companies' ownership is from their stockholders, who buy and sell securities as a way to gain profit, and shareholders has right in the company. Also, the financial information regarding the company need to be published to the public. Thank you. That's all from me. I'm Abdul Ashraf, and I would like to pass the next point to Amelia Asja.
Hello everyone, my name is Amelia Ramawati Asja. I would like to present about advantages and disadvantages for public company. The advantages for public company is, first, the members are having limited liability. Second, the ownership is transferable. Third, it's a separate legal entity. The business will continue in existence notwithstanding of no human being. Fourth, easier to raise capital. And the last one, advantages from public company is possible tax advantages. Next, we move to the disadvantages from public company is, first, expensive to establish. Second, need to comply with many law and regulation. Third, having restrictive powers. It means every act done must be consistent with its constitution and law. Okay, we move to talk about application for incorporation for legal aspect of public companies based from Section 14 of Companies Act 2016, which sounds subject to this act any 2 or more persons associated for any lawful purpose may, by subscribing their names to a memorandum and complying with the requirement as to registration from an incorporated company. It means application for incorporation must be made to the registrar. A company shall not be formed for any unlawful purpose. The application shall following particular: first is the name of the proposed company, second, the status of whether the company is private or public, third, the nature of business of the proposed company, fourth, the proposed address of the registered office and of the company, and the last one, information about director. Upon successful registration, a certificate of incorporation will be issued by the registrar. And the last one we talk about is separate legal entity for legal aspect of public companies based from Section 20 of Companies Act 2016, which sounds a company incorporated under the Companies Act 2016 is a body corporate and shall have legal personality separate from that of its member. It means a company in law is equal to a natural person and has a legal entity of its own and is entirely independent from its shareholders. Thank you for your attention. Next, we proceed to Ruben Jan.
So, today I'm going to talk about Section 21 of Companies Act 2016. Companies have limited capacity to control the activities of the corporation, facilitate effective entrepreneurial and prudent management that can deliver the long-term success of the company. Next, company is an artificial legal person and given recognition by the law. It has its own authority, rights and responsibility like an individual. Next point is, can sued or be sued. The company can sue any individual, including its director or other entities, for any wrongs commitment against it. Company can also be sued for its wrongful acts and omission. Members cannot act behalf of the company. It's about Section 21 of Companies Act 2016. Companies have unlimited capacity to acquire, own, hold, develop or dispose any property. The property of the company belongs to the company, not individual members. The company cannot take the property of the members and vice versa. Next, enter contractual capacities. The company has contractual capacity to enter a long transaction. The company can commence business by entering into any contract. Even though a company is a separate legal entity, it cannot act for itself but two individuals acting as agent of the company. Slide is about Section 192 of Companies Act 2016, liability of members. So I'll be talking about limited liability of members. A member shall not be liable for an obligation of a company by reason only of being a member of the company. Any debts incurred will be the responsibility of the company to discharge it, and its members are not liable for its debts. Members' liability is only limited by either share or guarantee. The concept of separate legal entity, also protecting the directors as well as other members despite being controller.
Perpetual succession refers to the continuing existence of a company. This contributes to the company's longevity and stability. Section 20 of Companies Act states that a company incorporated under the Act will continue in existence until it is removed from the register. A company is considered immortal as long as it has not been wound up or struck off by the register. Even if the shareholders sold their share to others, the company will not change its identity or personality. Section 152 of the Companies Act 2016. Prospectus. For a public company, issuing prospectus is mandatory because the public is invited to subscribe the share of the company. The purpose is to invite public to invest in the company shares, so the company can raise funds when the public investors buy shares of the company. A disclosure document to the public to allow the public to make informed decisions. Companies are required to file the documents with the Securities Commission Malaysia. Section 235 of the Companies Act 2016. The requirements of a company secretary. The Companies Act requires that every company have at least one company secretary, but more than one secretary is allowed. The duties and responsibility of a company secretary includes attend board meeting, ensure the company is in accordance with the Companies Act, maintain secretarial records of the company, handle and organize the annual general meeting, maintain regular communications with the shareholders and directors, prepare and file the company's annual return, update and maintain the company's statutory books and documents, update the Companies Commission of Malaysia (CCM) about any changes in the company's statutory information.
Legal aspect of public companies. Section 340 of Companies Act 2016 Annual General Meetings. Every public company shall hold an annual general meeting in every calendar year to transact the following business. First one is the laying of audited financial statements and the reports of the directors and auditors. Second one is the election of directors in place of those retiring. The third one is the appointment and the fixings of the fees of directors. And the fourth one is any resolution or other business of which notice is given in accordance with the Act or the Constitution. Director duties based on Companies Act 2016. First one is call meetings, including board meetings, annual general meetings, and auxiliary general meeting. Second one is make decision for the company. The third one is manage the company business and affairs. The fourth one is prepare and file required statutory documents. The fifth one is directors must fulfill both fiduciary and statutory duties to make sure that the director is acting in the best interest for the company. Supporting documents. First one is Law of Malaysia Act 777, Companies Act 2016. Second one is Suruhanjaya Security Malaysia or Security Commission Malaysia, known as SSM or SCM. In conclusions, being a public company has its own challenge and rewards. Entrepreneurs need to be aware of what those benefits, risks, and responsibility required under law before going into incorporation.